No. No, this, our screen don't work. Our equipment don't work.
Oh, why is he shocked that our equipment doesn't work? This is the 187th, this, but it never works.
Go back to the office without review.
All right, everyone, I'm gonna call the docket. When I call the docket, you need to stand and let me know you're here. Otherwise, I'm gonna assume you're not here and a warrant may be issued for your arrest. In custody is Jerry McGee, Johnny De La Rosa, Raymond McKinney, Alexis Gonzalez, Alexis Emiliano Gonzalez, James Wilkins Jr., William Richardson, custody, David McNew. Well, this is not turning out to be a good Friday's Eve. Shanna Jessamy. And after I struggle with that name, Ruben Maldonado. Is this the right docket?
Yeah.
Okay. Broderick Lewis. Thank you. Somebody dismissed his case.
Second row, sir.
Oscar Barrera. Oscar P. Barrera. Elon Gonzalez. Thank you. Craig Cantu, custody. Dora Bravo. Leo Cantu, custody. Jeffrey Flores, custody. Ezekiel Martinez, Christopher Rivera, Adriel Trevino, Christopher Cameron, Christopher Rios, custody. One, Andres Aguilar.
Yes.
Lorenzo Garcia, Allison Settle, custody. Xavier Chamberlain. That sounds like a soap opera name. The Chamberlains from, I think, Guiding Light. Brandon Bibbs, custody. Cody Wise Carver. Dominic Nicholson, custody. John Michael Garza. Thank you. Mitchell Evans. Jovan Amor, custody. Jordan Davis. Thank you. Alexandra Alvarez. Thank you. Robert Castillo. Ezekiel Neely. Justin Guzman. Justin Keith Guzman. Eduardo Rene Rodriguez. Eduardo Rene Rodriguez. I think that case should not be on the docket. So if you'll give me the information on that later, please. Or pull his file. Nathan Montoya, custody. Nicole Nutter, custody. Jerry McGee, custody. Ragaya Bergen Savala, custody. Seth McDonald, custody. Is there anyone whose name was not called or you came in late? All right, attorneys, please follow these rules. You're not ready to approach the court unless you confer with the state and confer with your client. If your client is in custody, your client needs to be brought out. Just request your client from the deputy. Once you requested that your client be brought out, do not leave the courtroom because there's a limited number of inmates that are allowed out for security reasons. Do not talk behind the court reporter when we're on the record. You know we're on the record because I will have called the style of the case. Do not approach the court. Do not approach the staff to my right while we're on the record. Staff, do not talk to anybody while we're on the record. If your client wishes to speak in a language other than English, we will need an interpreter. Let the court coordinator or the clerk know that you need an interpreter for your client. If your client is on probation, or if your client is seeking to have probation, confer with the probation officer, because at the end of the day, I'm going to ask the probation officer for their thoughts. The probation officer is right back there. Ms. Abrams, can you raise your hand? That's the probation officer. Knock on her door before you go in there. It's an invisible door, but knock on it anyway. All right, it's Friday Eve. Let's try to make this a great Friday Eve, because tomorrow is going to be an even greater day. Everyone, please confer. But Sean, always knock on your office door before entering.
You do.
Don't bring up this, so we stick in the file. I don't know if you bring
Alexander Alvarez?
That's what you're doing.
Your roster for that, you didn't answer, not call.
Hello,
Just how are
good
you?
morning. How are you doing?
Good, good.
Signature in the bottom. Yeah.
Thank you. No, have a good day. Thanks. Bye-bye. Tell me when. I don't care for who.
Second row, sir.
Alexis Gonzalez, David McNew, Shayna Jesme, Ruben Maldonado, Oscar Barrera,
Right, you go with what?
I just have to.
Yeah.
I just gotta.
Yeah.
Justin Guzman, Eduardo Rodriguez,
Talleros.
Who?
Juan Caleros.
But he did turn himself in, they went into the back to put handcuffs and shackles on him, but
Okay,
we're here about getting a bond set on a motion.
all right. When he comes, when they bring him back out, we'll have a hearing on it.
And this is him, Judge. That's fine.
All right.
Go make sure to have because I'm gonna take my.
If he'll come up, please.
It's just no information.
All right. Court is calling 2024 CR 5374 State versus Juan, how do you pronounce?
Cayeros, C-A,
Calleros?
yeah, what is it?
All right. Can I have parties announced for the record for the state?
Opinion for the state of Texas.
Nick Aguilar on behalf of Juan Caleros,
Yeah.
Gallegos.
All right. See, you pronounced it incorrectly, but I knew there was something that should happen with the double L's.
Right.
Which is a Y. All right. So you're here on a motion to set bond?
Yes, Judge.
Right, just one moment. Is there an agreed bond?
Well, they're agreed to a 10,000, which was twice the original bond.
Oh, all right. Could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Would you state your name for the record?
Juan Cayeros.
All right. So I have a few questions for you, and those questions that I'm going to ask you are related to conditions for bond, not the facts of the case. I don't know anything about the case. So have you ever had any type of mental health issues?
Not that I know of.
Okay. Have you ever been diagnosed with any mental health issues? Have you ever had to take any type of medications for mental health issues? In the past, I'm not talking about now. I'm not talking about at the time of this alleged offense. In the past, have you ever used any type of drugs?
Oh, well, like pills and stuff?
Yes.
Yeah, no,
All right. Any other drugs in the past? I don't need to know the name of them.
no.
And are you employed?
Well, I'm on monitor, so I'm on full house arrest.
I need to get permission to have him go to work. If you want to, the new charge out of County Court 13, I need to file a motion to go down there and allow him to go to work or go on partial GPS.
Mhm.
I guess while we're here, that's going to be an also requirement.
So I'm assuming that County Court at Law number 13 is the one who gave him GPS?
Yes, ma'am.
All right.
It's a violation of protective order and horrific threat.
And who is the alleged complainant in those cases?
What is it? Or with my girlfriend. My favorite ones.
Have you go last judge?
So I don't know if you put my case to. That was.
For the record, one of the two children is on the ABI.
Mhm.
I misspoke.
Okay. And is it the same complainant?
Different complainants on each station. For the church, the Tiffany Gomez.
And it's that TIFFANY? And you said Tiffany Gomez?
What?
So.
No, I was my girlfriend. She's the one who called it.
Excuse me, stop the chatter. Yes.
That's spelled M-A-H.
Mhm.
A-I-L-I-A.
And the last name?
Gomez.
All right. All right, this is what the court is going to do. The court is going to follow your agreement. The court is going to set your bond at $10,000. There's going to be full GPS waive fees. The court will note that he's currently on GPS. There's to be no contact with Tiffany Gomez and Mahalia Gomez, and there's to be regular UAs. Counsel, if you wish to have the full GPS removed, you need to come back to court for that.
Yes, sir.
All right, is there anything else from either side?
Nothing from the defense, Your Honor.
All right, we can go out the record. So there's a motion to revoke. We're gonna need to set this for a contested.
Yes,
Then
Your
if it turns out it is not a contested, you'll need to let the probation officer know at least a day before.
Okay.
All right, and with regards to the contested hearing, would you have any objection to the probation officer appearing by Zoom?
No, Your Honor.
All right, so probation on this case, it's going to be a contested, but the defense has no objection to the probation officer appearing by Zoom.
Can my client also appear by Zoom, Judge?
I like that. All right, so Ms. Ferguson,
Yes, ma'am.
if you can set this in 20 days for a contested, please.
Yes, ma'am.
I apologize, Judge. I knew the answer. I just had to ask.
Oh, no, here's the thing. My grandmother would always say, doesn't hurt to ask. All they can do is tell you no. I'm sorry, I did a no with a chuckle.
Yeah, I got no with a chuckle.
February 27th.
All right, the contested hearing on this case is going to be February 27th. State, I'm assuming you have no objections to the probation officer appearing by Zoom?
No objection, please.
All right. All right, so if you give him a reset form, please.
Yes,
Yes,
And with that, you'll be excused. Thank you.
Thank you.
Thank you for addressing appropriately for court.
Well, I've been here before, so I was like, I already know how you work. You know?
Okay,
You have to sit.
Thank you.
yes.
And protect them all.
All right. Could I see the file on John Michael Garza? Thank you. Thank you. John Michael Garza. If you'll come forward. Hello. Thank you for always being on time and dressing appropriately. All right, so your attorney isn't here yet, but the state is dismissing your case for missing witness. If you wish, you can be excused now or you can wait for your attorney. So you're welcome. So here's the thing. They're dismissing it because they say a witness is missing. They're not saying that it was insufficient evidence or anything of that nature. So do better, okay? All right, happy Friday's Eve for you. He's gonna give you the dismissal.
Second row. Amanda? Second row. Okay, thank you. Hey, Mike. Yes.
Yes.
The one that was supposed to be sealed.
I gave up my only.
He was concerned about doing it at all. I said, no, they wanted that.
Yeah.
Yes. She said, well, Mr. Hunter said he'd pay for it. I said, okay. Fine, but she was never giving it to Mr. Hunter, and I said, no, I think it needs to go to the court. If it's sealed.
Yes, it does. And if it's sealed, and if the record was sealed, they need to have a hearing on unsealing it. Yes.
So I told her, just bring it here and give it to me and I'll turn it down.
All right, thank you. Jason? If you could approach, please. The court reporter is telling me that the record was ordered to be sealed on the matter involving McIntyre. So if you can talk to Mr. Hunter, come in, we can have a hearing to unseal it.
Okay.
I'm assuming nobody will object to it being unsealed. I don't know what's in it, but we need to put that on the record before the court reporter can turn it over.
Okay, because. Transfer information?
She was gonna work on it.
Okay, so I don't, I mean, I'm sort of right in thinking that it was meant for me.
No.
Okay, good, okay.
And but I'll, do you want me to try to get, well, I'll text him to see if he can come in today or?
Yes.
Okay.
What page is was your client on the docket today?
No, Judge, it was an add-on, off docket. now.
Okay, all right, thank
But I
you.
was told today was a great day to get in, though.
Yes. And I just gave the information to Yaya, so if you want a copy of the bond being set.
That in the NPR.
I'm not in any hurry.
You want my boy?
Yeah.
Tell me how many days Brandon Gibbs has it on his case.
She'll help me do this. She'll be here.
All right, Deputy Laura, when you get a chance, could you bring out Cody Wise Carver?
I have requested him.
All right, Mr. Wise Carver, if you'll come down, please.
That mag number, but it's been indicted. They have a NIMAG number, but it's been indicted on the indicted case. 75
Hello.
316.
Hi, your attorney actually sent the court an email. He's out with the flu. So we would need to bring you back. He says next week.
Yeah,
But-
anytime- which time is it?
I've spoken to people who have this brand of flu. It takes longer than that. So I can put you on the docket for next week, but it's not a guarantee he's gonna feel better to come in next week. You understand? All right, Ms. Ferguson,
Yes, ma'am.
if you'll recall this for February 13th, please.
Yes, ma'am.
All right, so we'll see you back next Thursday. And if your attorney feels better and he wants you brought back sooner than that, he can let us know.
Okay.
All right, thank you.
Thank you.
163. Thank you.
Nobody.
To the state, Wise Carver is being recalled for February 13th. Yes.
Imagine we probably want John Lewis's attorney,
Yes,
so that I believe.
and they can appear by Zoom if nobody objects.
Oh, I talked to John Hunter. He said he may be available late this afternoon. He said he's in Bear County, but that's the San Marcos. I told him to reach out to Norma
Yes,
and then coordinate with Norma and you whenever he's available. But I'll reach out to the attorney on. He was a double down. Actually works for a lot.
Okay,
So I'll reach out to them.
all right.
Okay.
And if you are able to do it in the afternoon, if you'll let Norma know, and we'll see if we can have Mr. McIntyre by Zoom.
Okay.
Deputy Laura, the flu, COVID, pneumonia keep trying to find me, but I say I'm not here. It knocks on my door. I'm like, geez, I'm not here.
Second row, please.
Second,
Second row.
are you in for court or for someone? For someone. Have a seat somewhere else. All yours.
This is my second.
Good morning, Judge.
Good morning.
Mayor Burke.
Yes.
This is off docket. This is that trial that Charles and Kelly had, and we just need your signature for them to withdraw so they can get an appellate attorney appointed. And Judge, I told Norman, I have one inmate on your docket today. We're starting trial across the hall momentarily,
Okay.
but if we have a morning break, I'll definitely try to pop over here and
Sure.
do something.
Who's your client?
Christopher Cameron.
All right, thank you.
Yes, ma'am.
All right, I'll make sure this is given to them. I have to put it in the
May I
system.
take a picture?
Sure.
Okay, thank you.
Dora Bravo.
Morning, Judge.
Good morning.
Just so you'll know, the other day when I was in here, you made a joke about Jerry Goldstein said he was beating a dead horse. And you
Yes.
said that horse was glue.
Yes.
I don't know if everybody else got that. I wanted to know if somebody got it.
Thank you. No, it's glue. It's glue. You know, my mom always would say when she was doling out punishment, and you know, she didn't believe in corporal punishment, so it was always a conversation. And so to this day, you know what she always says? I know I'm beating this dead horse. And we're like, yeah, we get it, we get it. She's like, no, but you don't get it. She's like, I'm gonna dig it up and beat this dead horse again. All right, so on this case, where are we on discovery?
I believe we have everything. I just need to finish going through the videos.
Okay,
And I would just request one more reset. We do have an offer, but I would like to be able to finish going through the videos.
okay. And of course, I do not know what the offer is. I don't want to know what the offer is, but if you determine that this is a case where the state could prove it beyond a reasonable doubt, if y'all are thinking about PTD, if you could already check into that, that would probably help move the process along.
It would be great if they'd offer that, but
Oh, okay. I'm just throwing it out there. All right, Ms. Ferguson, on this case, if I can have a 30-day reset, that's going to be your plea deadline date.
Can I give them March 17th? I need to a little bit over.
March
That's fine.
17th. All right, you'll need to be back here on March 17th. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you, Judge.
Have a good one.
We'll have a seat. We'll take you.
Do you have the case back from Kelly, the motions that I signed? If I could have those, please. Just to make sure it's in my system. All right, thank you. Alexis Emiliano Gonzalez. David McNew. Oh, just have a seat, sir. Dana Jessamy. Ruben McDonald. Oscar Barrera. Thank you. Just have a seat. Justin Guzman. All right, for everyone here, if your attorney is not here, you have the court's permission, except for the people who are on the second row. You have the court's permission to step outside and call your attorney. And number, what page is Dora Bravo on?
She's on page 3.
All right, thank you. All right, does Brendan Wright have two? Ah, I see here.
Oh, thank you.
All right, yeah. On this one, I think they pled to the lesser. So it's, I don't see this.
Yeah.
Okay. All right, thank you.
It's not out of the corner of my eye. I'm just going down the line.
You saw the email that he's in the hospital, right?
So I'll just put. Jerry Flores and then let you know that he's.
Yeah.
All right, who's here on Jeffrey Ozzie Flores? Hi, where's Mr. Flores?
The hospital.
All right,
We got
so,
an email yesterday afternoon that he was in the hospital.
all right, is it an email from him or an email?
From the
hospital?
jail.
He was
All right.
on the screen back here, Judge.
All right, so, can I see a copy of the email?
Well, let's see if I find it. Of course, I probably didn't save it.
Here it is.
You got it? You forwarded it to the
Yeah.
judge? Okay.
I'm just waiting to receive it, counsel. All right. So we'll recall this back at the end of this month.
All right.
What date? All right, so we're gonna put this on the 27th.
Okay, that'll work. 27, yeah.
Your Honor, may I
Yes,
approach?
yes.
Judge, I have a dismissal for you. And the reason for the dismissal, as it's been explained to me, is you had subpoenaed the state to get,
Oh, did you ask them to pull the file?
I did not. Mitchell Evans, please. I apologize, Your Honor, I'm
No
a little
problem.
ahead of myself. They weren't able to get that information. So they're dismissing for missing witness.
All right, where's your client?
He's here. Mitchell Evans.
What page is Ozzy on for us?
He is on page 4, Judge.
I skipped right over it. I'm like, the way they do this docket. All right, thank you.
The 27th.
All right. Let me pull this case up. All right, Mr. Evans, the state is tendering a dismissal. They're saying it's for missing witness, not for insufficient evidence. Do you understand?
Yes, Your Honor.
So I don't know what brought you here other than the charges that you have. But if there is some sort of issue that's going on with you, you need to correct it. Otherwise, you're going to be back in someone's criminal court. You understand?
Yes, Your Honor.
And Your Honor, I'm requesting if the court would make the dismissal with prejudice so that we could do an immediate expunction. There were issues with the stop, which we're talking about doing a motion to suppress on, but they decided to dismiss because they were not able to get the information subpoena that you ordered them to subpoena last setting. And I just want to make sure for my client that I can do an immediate expunction for him.
I am not going to grant a motion to dismiss with prejudice.
Okay, thank you, Judge.
You're welcome. Yes.
On page 8.
Thank you.
Ready to go sentencing.
may I reapproach your honor?
Sure.
Judge. I just want to get my thoughts organized here.
Sure.
At our last hearing on this case,
Mhm.
You ordered the state to subpoena the information that was missing.
Mhm.
They did not subpoena the information that was missing. They didn't initially say, yeah, we're going to dismiss this case.
I'm sorry, just if you could hold on a moment, that's the printer is running and,
I understand. I
All
have
right.
that problem too.
all right, yes.
Maybe we should put this on the record.
Sure, you want to bring your client up?
Yes, Mitchell Evans.
Could I see the file on Mitchell Evans, please? Court is calling 2023 CR 6408 State versus Mitchell Evans. Can I have parties announced for the record for the state? For the defense?
Linda Corley for Mr. Evans.
And are you Mr. Evans?
Yes, Your Honor.
All right. So that the record is clear, the state tendered a dismissal, and that dismissal was based upon a missing witness. The court signed the dismissal, and the defense asked that the case be dismissed with prejudice so that her client's case could be expunged. The court denied the defense's motion to dismiss with prejudice. Defense, and there's something you wanted to put on the record?
Yes, Your Honor. When last we were at court, the last hearing, Judge, you ordered the state to subpoena some missing discovery that we've been trying to get since, I believe, the court had noted on the record last fall, I think October or November. I'm not sure on that date. We came back to court today. The state had not subpoenaed the information. I also talked with the prosecutor and he was unwilling to dismiss the case. And
I'm sorry, could you repeat that last
he
thing?
was unwilling to dismiss the case, feeling that it was a case that might be good for a motion to suppress. However, he didn't feel that it should be dismissed. And after further consultation, I guess amongst themselves, they decided to go ahead and dismiss the case based on what was first marked as a further investigation, which I had issues with. And so it was, after discussion between the prosecutors, changed to missing witness. Judge, what I don't want to have happen to my client is to have the prosecution do a workaround to give themselves more time to get information that would have otherwise probably been suppressed and then go forward with the case. That's my
State, are
concern.
you, on the record, are you planning to re-indict this case or refile this case?
I did do attempts to reach out to China Group and they didn't respond to me, so I think missing witness is the appropriate designation on the dismissal, because I'm not sure who I am supposed to subpoena if nobody is reaching back out to me.
All right, so the state has no intention to refile this case?
Yes, and I.
Wait,
I'm
just a
sorry.
second. So state has no intention to refile this case? All right, you may proceed.
I'm sorry. And I am definitely not disparaging our prosecutor here. She has actually, as far as I know, she's reached out to China Grove multiple times and they have completely ignored her. But they did not issue a subpoena. And at the last hearing, we specified it was for the officer that he would have the information about the call. So they did not subpoena. I guess, Judge, I'm just in an abundance of caution. I would like for you to rule on, I would ask that just in case anything happens, prosecutors change. I would like for that information that was to be subpoenaed, specifically the information about the call and the additional, all of that the officer put in his report. I would like for that to be suppressed, just so that in the event that something does happen, and this case does get refiled, they didn't get to do a workaround because they didn't follow the court's order.
All right, so what the court will say on the record is, as far as the court making a ruling on a motion to suppress, the court does not have a motion to suppress before it, so the court cannot suppress any evidence. I don't even know what the evidence is. The state has stated on the record that they have no intention of refiling this. I would think probably the best thing to do is to ask the court reporter to print off this record where the state said that they will not be refiling this.
And Your Honor, if I may,
Yes.
I'm not asking you to grant a motion to suppress that hasn't been heard. What I'm asking you is to suppress information that was not properly disclosed under 3914 in a reasonable amount of time, and that is an option that and a resolution that has been used by courts before whenever information was not provided under 3914 properly, that information was suppressed as the remedy.
All right, so it is hard for the court to agree that some information should be suppressed when I have no idea what the information is. Sometime the remedy is defense is allowed an opportunity to review the information, maybe call different witnesses if need be. But for the court to enter a suppression of evidence that the court hasn't seen, I'm not going to do that.
Your Honor, it's not information that's unknown. And I appreciate your patience with me, Your Honor.
No.
It's not information that's unknown. We know what it is. We know that the officer said that he received a call on his cell phone giving information about a car that was driving recklessly. And so we know what that is, but we don't know who the caller was. And so the order was to subpoena to get the information about the caller. So we know exactly what the information was, and they failed to get it. We've been trying to get it since last fall. And so that would be a violation under 3914 and a normal remedy for that, because the 3914 really doesn't have any teeth in it. The only remedy we have is then for the court to say, well, you can't use that information if it was to go forward. That information is suppressed. You can't use it because you didn't abide by 3914. And that's all I'm asking the court to do.
All right, anything from the state?
The judge just got an agreement. I've already stated that we follow the case alternate adjudication system.
And again, Judge, this was just an abundance of caution to represent my client effectively.
No. I appreciate your arguments. The court is going to deny your motion. My suggestion is that you obtain a record from the court reporter. Cindy, if you'll make sure that she has a copy of this hearing, and you just need the portion where the state said that they would not be refiling this case. And then if need be, if you need to call me as a witness, I will come as a witness if they refile it.
Thank you, Your Honor.
Without subpoena, well, I'll need a subpoena, but just know I will come and I will testify.
Thank you for your patience.
No problem. All right, you all have a good day. All right, are the parties ready on Jerry McGee? All right, court is calling 2025 CR 0000220, State versus Jerry Kyler McGee. Can I have parties announced for the record for the state? For the defense?
Ron Ross.
All right, are you Mr. McGee?
Yes, ma'am.
All right, you entered a plea of guilty to count one. Count two was waived without objection. Just one moment, let me let them finish over here. Okay. All right, count two was waived without objection. The court found there was sufficient evidence to find you guilty. The court found you guilty. According to your plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. The state is opposed to your application for community supervision. They're taking in consideration 2024 CR 007651, 2024 AL 001409, and the following night magistrate numbers: 751980, 751981, 751982, 751983, and 751984. In this case, no PSI was prepared. Defense counsel waived PSI. The court reset it to give parties a chance to have witnesses present if they wanted to have witnesses present. There was no objection to the court requesting the defendant's criminal history. Is that correct, counsel?
That is correct. You actually gave us the option of a PSA or to go forward, and we're gonna opt to go ahead and go forward.
All right. So state, you are opposed. Why are you opposed?
Resulted in what could reasonably describe as a crime wave. Not the worst crime wave that Bear County has ever experienced. Crime wave.
Just one moment. Excuse me, counsels. If y'all could step back, I'm trying to hear. Thank you. All right, counsel, you may continue.
These offenses stretch up to October 31st of 2024. So from the state's perspective, it seems that the only reason that Mr. McGee has committed additional offenses is because he has been confined. The state doesn't see considerable evidence to indicate that probation is appropriate in this instance, because the state does not perceive much evidence that absent confinement, Mr. McGee will keep on the straight and narrow, which is why the state believes that supervision is not appropriate in this.
All right. So with regards to the cases that are being taken in consideration, were those offenses alleged to have been committed on different dates?
Some arose out of the same criminal episode. Some are actually not being taken into consideration. That's my mistake. The UUMP is being dismissed for missing witness. Property is being dismissed for missing witness. The PG 2 1 to 4 is being dismissed for insufficient evidence, because as far as I can tell, the PG 2 substance was not actually tested by the Bear County criminal investigation.
All right. So if you will tell me the cause numbers that are not being taken in consideration, but are being dismissed for other reasons so that I can notate.
Start with X 751980.
Okay, yes.
9975198
Hmm?
Clause number 2024 CR 007651.
Mhm.
And petition 2024 AL 001409 will be rejected. That is an at-large case. I spoke with the complainant in that case, and he is going to be making opposite.
All right, so the night mag number that ends in 80, what is the reason for that dismissal?
Insufficient evidence.
And the night mag number ending in 983?
Missing witness.
And the cause number, the 2024 cause number?
Missing.
And then the AL number is being rejected. So that, any objection to the court then changing the paperwork?
No objection.
All right, so what the court will do is the court will remove from the plea bargain agreement that 2020 4 CR 007651 was being taken in consideration. The court will remove 2024 AL 001409, NIGhtMAC number 751980, and NIGhtMAC number 751983. So then the items that will be, the offenses that will be taken in consideration are NIGhtMAC 751981, 751982, and 751984. So with regards to the offense that's being taken consideration ending in 8-1, what is the offense date on that one?
8-1 was, I've got February the 18th, 2024,
All right, and 8-2
same date,
and 8-4?
same date.
All right. And then this, the instant case is October
31st.
2024.
Yes, ma'am.
All right, state, is there any other criminal history for Mr. McGee?
There is one prior offense. You'll give me a moment.
Yes.
Check the CIC.
All right, and what's the,
500 out of Green County. For adjudication, which he successfully.
all right, and what is the offense date on that? Or the conviction date?
Disposition date is March 31st of 2020.
All right,
And that is all of the prior criminal history which I'm here.
all right, and state, you may continue your argument. All right, defense.
Judge, may I ask my client some questions?
Yes. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
You can lower your hand, state your name for the record.
Jerry Kyler McGee,
How old are you, Jerry?
33.
What kind of education do you have?
I have a bachelor's degree in biology and a double minor in mathematics and chemistry.
Okay. Have you, what is your work history?
I've worked for myself and then as well as a few different laboratories and medical sales companies here in town. And that's kind of what I specialize in.
Here in town, okay?
Yes, sir.
Have you lived here all your life?
No, sir. I came to San Antonio in 2015 to attend a master's degree program and as well as work.
Did you ever leave San Antonio?
I left San Antonio for 1 year. I went to Waco, Texas for 1 year.
When did you return?
When I returned is when right about December of 2023.
About a year ago?
Yes, sir.
Okay, are you married?
Yes, sir.
When you went to Waco, did your wife go with you?
She did.
Do you have any children?
I have a daughter. She's about to be 2 years old.
Okay, and when you returned to San Antonio, did you return with your wife and your child?
I did not.
Why not?
We were getting a divorce.
And where does she live now?
She lives in West Texas.
Do you see your child
I do.
very often?
As often as I can.
Okay, when you returned to San Antonio, were you able to get a job?
No, I was having a tough time finding a job.
Did you have a place to stay when you moved here?
I did.
Okay, and so how did you get into, you've had several incidences here. Most of them are misdemeanors or they're state jail felonies, small things, but how did you get into doing three different instances? How did you get into that?
I've just fell into the wrong crowd and I take full responsibility for my actions. I shouldn't have been hanging around the people that I was with and, committing the same crimes that I had been charged with. I was down on my luck. I couldn't find a job and I was doing what, anything possible to do what I needed to do to make money. And, you know, that was wrong of me. And but I know that, you know, I deserve probation. And I really know that I can, you know, take classes and do community service and be responsible about it. And I know it's something I can complete because I have done it before and I know I can do it again. I hope the court will grant leniency on it for that.
And also a job, you need a job. Are you gonna be able to get a job?
Yes, sir. Yeah. Yes.
One way or the other, you're gonna have to work. If you can't get a job in your field, you're gonna have to get a job.
Yes, sir. Yes,
You
sir.
willing to do that?
Yes, sir, I am.
You understand if you're given probation, you mess up, you come back, you're gonna go to prison.
I do, and that will not happen.
Have you ever had probation except the one case 10 years ago? You ever had
I've
probation?
never been in trouble in my life. Besides it.
You ever been to prison?
I've never been to prison. No, sir.
Never been to jail more than a few days on these cases?
I never, no, sir. This is the longest time I've ever been in jail, a little over 3 months.
Yeah, what is the situation on your divorce with your wife? Has anybody filed?
Yes, filed. So we're currently, when I get out of here, it'll be finalized.
You're asking for probation.
I am asking
You
for
understand
probation,
that
yes.
Probation's not easy.
I know it's not easy, but you know, I am a strict man. I've decided this is not for me. And I understand that I can't complete it. I come from a great family, I've got a great backing, behind me, a great family behind me, and I know it's something that I can complete with, you know, in a timely manner and complete it successfully very easily.
Judge, I would ask you to give him probation, and I'd like to point out that the cases that we're going
Oh,
forward
just
on.
one second. Do you have any questions? All right, I have a couple of questions.
Sure.
You said you deserve probation.
Yes, ma'am.
What does that mean? That you deserve probation?
I feel like it's something that I deserve. I have not. My past history has shown that I have not, you know, committed crimes. You know, my whole
I
life.
just find that sort of like a weird
No, I would
statement.
appreciate. It's probably a better
Yeah.
word for it. Yes, ma'am.
Because, you know,
It's
people,
something I don't deserve. Yeah,
yeah,
I
because
give it
people
to you.
deserve, in Bear County, people deserve people not to commit crimes,
Yes,
right?
ma'am. Yes, ma'am.
All right, we're gonna go off the record. All right, who's here on Nathan Montoya? How's it going, David?
How you doing?
Hi, all right, you were here last time and somebody was like, David spoke to you. Didn't you hear him? I'm like, no, I didn't hear him.
Oh, no worries.
So how's it going?
Everything's good, Judge.
I hate you were not able to come to the
I wasn't
event.
able to make it.
Hey, we're now in the congressional record. Who would have thought,
Oh,
right?
Yeah,
So it was a lot of fun.
it looked like it.
And I ended up sitting next to Supreme Court Justice Wallace
Oh.
Jefferson. So it was
Yeah,
it's cracking jokes. It was a lot of fun.
good deal.
All right. Court is calling 2024 CR 008168 State versus Nathan Tyler Montoya. Can I have parties announced for the record for the state? Defense.
David Andre.
Quiet,
Woodard
please,
for
we're on the
Mr.
record.
David Andre Woodard for Mr. Montoya.
And are you Mr. Montoya?
Yes, Your Honor.
All right, you entered a plea to the lesser included offense of no contest. The court found there was sufficient evidence to find you guilty. The court deferred finding of guilt as you applied for deferred adjudication. According to your plea bargaining agreement, punishment is to be assessed at a cap of 7 years in the prison. There's a $1,500 fine. The state is opposed to your applications. This will run concurrent with County Court Cause number 734433. There should be Chapter 62 registration and no contact with the complainant. Have both parties had a chance to review the TAP evaluation and PSI report, state?
Yes, Your Honor.
Defense?
I have, Judge.
Any objections to the TAP evaluation or PSI, state?
Not this, Judge.
Defense?
No, Your Honor.
All right, state, you are opposed. Do you have any witnesses?
We do not, Your Honor. In lieu of the witness, we do have a letter from one of the witnesses, will enter it in as State's Exhibit A. I believe there's no objections.
No
And I
objections, Judge.
will reserve our argument.
All right, then the court will accept into evidence State's Exhibits A if both parties will give me a chance to review it. All right, if you'll give that to the court reporter.
Yes,
Thank you. And if you could, I think it's marked on the inside as State's Exhibit, correct?
it is.
All right, defense, do you have any witnesses?
No, Your Honor. Only argument.
All right, then, the court will hear argument. State, you are opposed?
We are opposed, Your Honor, but we'll reserve.
All right, defense?
First off, Judge, looking at the PSI on page 2, this is Mr. Montoya's first interaction with.
Just one moment. Excuse me, counsel, if you, Ron, if y'all could just move to the other end. Hi, if you could just move to the other end, we're on the record. No problem. You're our counsel. All right, we're back on the record. And counsel, what page did you say?
I'm on page 2, Judge, of the PSI regarding Mr. Montoya's criminal history.
Yes.
The only criminal history that he has, Judge, is this current case and also the misdemeanor case that's going to run concurrently with this case. Aside from that, he has no prior criminal history. He's 30 years old. At the time of the incident, he was employed at Amazon. He was working. This case was resolved fairly quickly, Judge. Mr. Montoya accepted responsibility fairly quickly. He took a plea and now we're here before the court. since he's been in custody, I believe since May of 2024, he's had no contact with his brother who drafted the letter, I think that was State's Exhibit number A. And he's also had no contact with the young child who is his niece. Speaking with him, he realizes what he did was not only wrong and inappropriate, but was also a criminal offense. Also, there's a TAP evaluation that is the last page of the PSR report. And the TAP evaluation does not show that Mr. Montoya has any substance abuse issues or any alcohol related issues. We are asking the court to grant his application for deferred. I know it's a difficult case, of course, to consider granting a person deferred adjudication. We're asking the court to give Mr. Montoya that opportunity, one, because he has been in custody. He's had time to reflect and to think about what he did, not only what he did, but the repercussions that happened with his niece. Looking at the PSI and also the letter that the state submitted, it does look like the niece did go through some mental health trauma. She likely would still continue to experience, but she has been doing well in school. There will be no other contact with Mr. Montoya and the niece. And we're just asking the court to consider his application for deferred adjudication. If the court does not consider that application, I believe the plea bargain was for a cap of 7 years. We're asking the court to possibly consider a downward departure and placing him in TDC for a lower amount of sentence opposed to the 7 years.
All right, is there anything you wish to say?
I do accept responsibility for my actions.
All right, just 1 second. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, that nothing but the truth, so help you God? That's it.
Yes.
All right, you can lower your hand, state your name for the record.
Nathan Montoya,
All right, so what did you want to say?
accept responsibility for what happened, and I do take accountability for that. I do wish that they're able to have the help that they need, and that should do it. I just want to say that I am excited for everything that has happened. I am a responsible man and will do what I can to become a better man each and every single day afterwards.
All right, I appreciate your accepting responsibility. The one question I have for you is why? Why did you do this? And the reason why I asked that question, because that's a part of, I think, an introspection, right, to yourself. So why? And I think sometimes understanding why we do certain things will help us not repeat it if it should not be repeated. So why?
Why? I believe I do need more self-reflection to understand as to why it was something that should have never been have done. Going through my own depressive episodes and self-loathing, I would say I have caused myself to go down a spiral of deep creativity, I believe.
Mhm.
However, I am able to bounce back up and to truly self-actualize myself. As to why, or that it may be because I'm also myself a victim itself, and I understand that happens because of that, that kind of thing. I'm still trying to come to terms as to why, basically. I don't like saying I don't know yet.
Okay.
But it is something that I do regret. I have lost something precious to me. Understand?
All right.
If I can say.
All right, any questions from the state?
Not
All right, thank you. I appreciate your testimony. All right, this is what the court is going to do. The court is not going to grant your application. The court will find you guilty. This will run concurrent with County Court Cause Number 7344433. There should be Chapter 62 compliance. There should be no contact with the complainant. There's a $1,500 fine, time and money run concurrent. Court will give you credit for any time served. I am unsure if the therapeutic community, if you will qualify for it. I'm going to request it for you because I think there are some mental health issues and some trauma going on with you based upon what has happened to you and based upon what I read in the PSI report that he has brothers who are in prison for the same thing. And one of the brothers was actually a perpetrator of him. And the court will sentence you to just 7 years in the prison. Is there anything else with regards to sentencing from either side?
Not with regards to sentencing, Your Honor, we do have
All right.
Not from the defense judge.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. With regards to the therapeutic community, you will still have to request that. It doesn't increase the time that you're in custody, but it can help you, I would say, deal with your past trauma. You understand? I do appreciate that you accepted responsibility for this. Sometimes people never accept responsibility. Sometimes they blame other people for their actions. Is there anything else before the impact statement? Will there be an impact statement?
yes, Your Honor.
All right, and the impact statement, is that the complainant or the family? All right, then let me do this. All right, so what's going to happen now is there's going to be an impact statement, right? So you will stand over there and just internalize what is being said to you. Yes.
I just wanted to write you this letter to let you know of all the ways you have made this impacted our daughter's life. However, you don't deserve to know anything about her and what she has been through. So instead, I'm writing you to tell you about the impact her choices have made to me, Tasha, and Tanya. First, me. You have caused all of my past childhood traumas to come soaring back with a vengeance. I literally felt the pain and heartache that I felt as a child when I was preyed upon by a pedophile. You caused me to question my sanity at times. Is this real? Did this really happen? You caused me to mourn the loss of a life that didn't even die. I mourn you, the you I thought you were, the you I would confide in, the you that I thought was one of the good guys. Yet instead you crept in like a wolf in sheep's clothing. My marriage went to shambles soon after finding out about the things you would do to our daughters. I lost everything in the wake of you. Second, Tasha, the pain and heartache you have caused her is immeasurable. The thoughts that race through her head pain me. I can see the pain you have inflicted when I look in her eyes. She too had to mourn the loss of you. We are both in pain over this. We both question daily if we made the right decisions in life for our daughter. If we had known the signs, could we have prevented this from happening? We struggle with this daily. Third, Tanya. She too has to mourn the loss of you and question herself daily if she had only known what she could have done to prevent this from happening. I would like to think you are smarter and had a bigger heart than to do this to our family, to yourself. You could have reached out and asked for help instead of harming our innocent daughter. You really messed us all up emotionally, mentally, and financially. I hope to God that you get the max sentence, because not even that is long enough for the chaos from you that still ensues. I hope when you get out that life is miserable for you and that the courts and parole that you've been through every single year they've got. You put yourself in there, you did this. I have nothing more to say.
Thank you. Excuse me,
Hey,
who do you think, wait, who do you think you are?
sorry.
No, and don't even act like you're over control with emotion. They're taking you back. Hi. Whose client is that?
Fine.
All right,
One of three, so I got to two now, a little more manageable.
all right, if you let them put him in a holding cell. He's overcome with emotion and he doesn't even know.
I'm a very emotional German.
Like, who's here on Alexandria and Marie Alvarez? Hello.
Hi.
Hi. All right, you're requesting a bond?
Yes, for two of her cases for which she's got motions to enter.
Okay.
And we did get a reduction in county court two. There is a motion to enter in that clause as well.
And did you confer with the state on the bond amount?
Yes.
I signed, my agreement on the. Okay. I think she's gonna ask for a less.
All right, so let me find.
Would you like a copy of that motion to enter?
Oh, no, I'm just trying to find, it's this one with the agreed order. Okay. And counsel, this is back to you.
Thank you.
You're welcome. I better like that one. All right, we're gonna go on the record. Court is calling 2023 CR 10964 and 2024 CR 2671, State versus Alexandria and Marie Alvarez. Can I have parties announced for the record for the state?
Christine Brown on behalf of Alexandria and Marie Alvarez.
And are you Miss Alvarez? All right, in each of the cause numbers, this defense has filed motions to set bond. Of course, the defendant is entitled to a bond as she is on deferred adjudication in each cause number. It's court's understanding that you all have come to an agreement of $10,000.
It's actually not correct. The state would agree if we were to come to an agreement to 10,000. I am asking for a reduced bond based on her current resources.
Okay. All right, then, state you're recommending a bond of 10,000? All right, defense, do you have any witnesses?
We don't have any witnesses. We just have the client. I do have her mother if she would like to testify as well.
All right. You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yeah.
All right, you can lower your hand, state your name for the record.
Alexandria Alvarez.
All right, you may ask questions.
Yes. Alexandria, when did you find out that you had this motion to enter or warrant?
Excuse me, sir, you need to have a seat.
When did you find out that you had a warrant issued for your arrest? All right. And what is your understanding as to why you have a warrant for your arrest or warrants for your arrest?
Because
I got arrested in Guadalupe County. And because of that, I violated my probation in Bear County.
And what other conditions were you aware that you needed to comply with? Can I have her review the motion to enter that she
Yes.
was given?
Oh, yes, yes, parenting class and theft class.
So what would you do to address those violations? Yes.
Yes, I will do that.
And who is representing you currently on the outstanding charges in Guadalupe County? Would Miss Macias, Amber Macias ring a bell?
Yes, sir.
Okay. And to your understanding, when is your next court date on those pending charges?
March 4th.
All right. And what do you do for a living right now?
I'm a hotel housekeeper
All
at
right.
Staples Suites.
What employer?
Staples Suites,
And how much are you making approximately?
$13 an hour.
And if the bond were set at $10,000, would that be unduly difficult for you?
Yeah, yes, ma'am.
Okay, and how often do you get paid?
I get paid weekly.
Weekly? And what are your living arrangements right now?
I'm living with my mother.
Okay. No further questions, Your Honor.
All right, any questions?
No.
All right, I have a few questions. So have you ever been have you ever been diagnosed with any mental health issues?
Yes, ma'am.
All right, and have you ever used any type of illegal substance in the past? And what would that be?
Methamphetamines, Xanax, and marijuana.
All right, and what has been your previous diagnosis?
My previous diagnosis was, well, I do have a TBI, traumatic brain injury, so I don't know if that is considered a.
I mean, as it relates to your mental health.
Oh, and then, I'm dyslexic and I have ADHD.
Okay. All right, any other questions?
No, Judge.
All right, so state you're requesting the bond be set at $10,000. Why?
This is in another county. My understanding she didn't have permission to keep this content, so. She's on probation in this case, she took 15 cases, that's the reason that I'm requesting it.
And what are you requesting?
I believe I had requested 3,000 in there for each cause.
All right, this is what the court will do. In each cause, the court will set your bond at $8,000. The court will order full GPS. The court will order that the fees be waived. Ms. Ferguson, I need a contested hearing on this case, please.
Yes, ma'am.
And if you could do it in 20 days.
Yes. I can do the 24th, Judge.
All right, is the 24th good for you, counsel?
24th of February?
Yes.
I have 2 trial settings on that day, so.
Okay, let me see. All right. Are you able to do February 20th?
February 20th?
Yes.
I should have no issues with that.
All right, Norma, if you'll set this for contested on February 20th.
Yep.
All right, thank you. Thank you.
Thanks.
Yes.
You need a motion to set bond.
Oh, I need your client here.
Yes, yes.
All right, so if you'll give it to them,
Oh.
we'll call it.
Mr. Rios, there are no files because apparently they're being transferred to the big traffic, 399.
He's in custody in the box, so you know where he's at.
I learned this information on our file.
Yeah.
But if he's back there, I'd like to see. That's the basement. Since he's.
No, we don't bring them out. Did you?
Not yet.
Oh, then, no, we don't have them. We have too many inmates that we.
But I got your question. What's that? No problem. I'll find it. Thank you.
On McLean. I think they're ready to restart that proceeding. With you all, the judges. Thank you.
Yes.
So I just wanted to clarify, that was just GPS, no house arrest or
No, it's full GPS.
full GPS?
Yes.
Okay, thank you.
You're welcome.
Might be a couple more days.
Okay, no, that's all right.
Around about that.
All right, Xavier Chamberlain. Hello.
Good morning, Your Honor.
Morning. So where are we on discovery?
Yes, Judge. With regard to discovery, the defense counsel we do believe there's outstanding evidence at this point in the form of videos and PDF reports, Judge. We'd be requesting a continuance for that, or reset for that basis, Judge. And I'm gonna go ahead and email this morning the state with particular things that I believe are missing with regard to each of these cases.
All right, and state the discovery that defense counsel says they're missing. Do you have that in your custody?
We cannot. So I can double check. There are a number of cases. I was still going through them. If we do have them in our custody, personal language, get it to defense. My understanding is that we cannot. Additionally, there's an outstanding case that we are waiting on to see what's going to happen.
Yes, Judge, just to follow up on that, I went through meticulously each of the cases and evidence that is ordinarily produced is not there. There's no videos in terms of body cams, dash cams, anything of that sort, and arrests were made in conjunction with this. So I do believe that there's some things that law enforcement may have, but I'll be requesting the state look into that.
Okay.
To clarify, I'm sorry, Judge, I think I misunderstood your question. The DA's office is not.
No, that's what I mean when I say, yeah, I know it's in existence, but I always want to know if you have it in your physical custody. All right, I need a 30-day reset for discovery.
March 17th.
All right, we'll come back on March 17th.
Thank you, Your Honor.
Welcome. Thank you.
You said for discovery?
Yes.
It is, if it's white.
Thank you so much.
No, that's fine. Oh, we don't have a meeting.
Richardson? Bids?
Are y'all ready on McGee?
We would like to send a supplement to states that wanted to.
All right, we're gonna go on the record. We're back on the record in 2025 CR 0002220 State versus Jerry McGee. Can I have parties re-announce for the record for the state?
And Harris Taylor.
Hey, Ron Ross for defense.
Right. And stated you would like to supplement the record or supplement the stipulations?
Yes, Your Honor.
Any objection?
No, we have no objection here.
Yes. And
In addition, we have a stipulation for the record.
sure. And do y'all have the original steps? Were those given back to the clerk?
I don't know where they are. I never had them.
And it's on,
Again, Your Honor.
yes.
Apologies for the inconvenience.
No problem. Thank you. All right. And if both parties will give me a moment to review the
Sure.
additional stipulations. All right, the court has reviewed the supplemental. And Defense, you wanted to add something?
Yes, Judge, the reports between the narratives and when they list the people involved, there's been some conflict between the different reports. They referred to my client as S1, S2, and I think at one time S3, and they've used the word P1, P2, and P3 and D1 and D3, I believe. We will stipulate that in this case, in fact, my client was the passenger in the car. He was the one that had the drugs. And I think that some of the reports refer to him as S2.
So do you understand your attorney's stipulations, and do you stipulate to what your counsel has just stated for the record?
Yes.
Anything else from either side?
State.
I would just ask you, Judge, to give my client probation, and what he did was he's not done anything that was aggressive or use of aggravated. They're third degree offenses or stage offenses, the several different ones he had. He's testified he's had a bad year last year, mentally, emotionally. He has no prior, he has an education, he can go out and get a job. I would ask you to give him a chance on probation. If you really want to hold a hammer on him, we didn't apply for it, but give him deferred. Really hold a hammer on it, but I don't see any reason for prison for him. I think he can get his life squared away.
All right, the court will note that he's charged with possession of drugs and not possession with intent to deliver. The court will note that there may have been some slight confusion with the police report and the way the police report was written. So the person who is in the vehicle with you, who is she to you, or who was she to you?
She was just a friend.
No, I mean, you just don't roll around in a stolen car with just a friend.
If you look at it, I was actually running, I was working out, and she picked me up in that car. So I was in the car for maybe 2 blocks.
Oh, so do you want a jury trial? Because if you're in the car for 2 blocks and you just get in a car with a complete stranger, which, how old are you?
33.
All right, you're 33. I've never heard of somebody running and just picking up a complete, letting a complete stranger pick them up unless they had some nefarious things in mind. Here's the thing, these drugs were found in the vehicle, they were not found on your person. Do you want a jury trial? Because you're telling me now you've gone from I deserve probation to basically I didn't do it. I just completed my workout and I'm running, I guess, as a
No,
part of
I had a bag in the vehicle. I knew who she was. I had a bag in the vehicle that she just came out, and like I didn't expect her to be driving. She just came up.
No, here's the thing. We're not dealing with a stolen vehicle. What we're dealing with is you're in a vehicle with a lot of drugs.
Yes.
So what you just told me, and if I heard incorrectly, please correct me. I take no offense to it. You told me you had just finished working out. You barely know this person and they picked you up. So you got in a vehicle with them. Did I mishear?
That's what he said. That's what you said. That's correct. He also said he had a bag with him.
Yeah, I had a bag in the car.
So these are your drugs.
Portion of them this time.
So why do you have drugs?
Hmm?
Why do you have drugs?
I was pulling down on myself and using the wrong exits to do it. Getting a clear conscience now and having a time to reflect on it. I know it was a dumb decision and it's something I'm never gonna do again.
All right, the court is going to find you guilty. I'm going to give you a choice. I will sentence you to 2 years in the prison today, or either I will place you on 8 years probation. Oh, so here's the thing. We don't need people in the background telling him what to do. This is not The Price is Right. All right, so what would you? All right, the court is going to find you guilty, sentence you to 8 years in the prison, suspended and probated for 8 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days of release. There should be no employment as a home healthcare provider or with minors. The state is taking in consideration NIMAG number 751981, 751982, 751984. There's going to be field visits 1 time per month until further notice.
Apologies for the interruption.
Yes. Yes. There's to be no contact with what is that noise? Do you hear that? Am I the only person hear that?
Sounds like music.
Oh, okay. All right. Thank you. Oh, no problem. I thought I was, I was losing my hearing. Thank you. There's to be no contact with Savannah Lee, Devin, Devin, Sanchez Martinez. Is there to be any restitution as it relates to this vehicle?
I'm not aware of anybody.
State.
Your Honor,
Yes.
Mr. McGee is not accused of the UUMD that arises out of the state.
That's true, too.
Possession of controlled substance 3.142.
All right, there's to be no unsupervised contact with minors.
Except maybe his child, he has a child, if he has to see a child.
So,
No unsupervised contact with minors.
so to answer your question, Your Honor, there may be restitution, but as far as we can discern, Mr. McGee is not the one.
All right, so you all are not asking for restitution. That's my question.
Correct.
All right, thank you. So there's to be no unsupervised contact with minors. There's to be 200 hours of community service restitution. The court will waive 50 of those hours once parenting classes are completed.
Probation will go wrong.
And probation, there can be a TAP evaluation out of custody. Follow TAP recommendations. And there's to be 120 sober meetings in 120 days. Probation, is there anything else? Is there anything else that you need from the court in order to be successful?
What's your question? Like AA or NA?
Okay.
Everything.
Anything else you need in order to be successful?
No, ma'am, I appreciate you and appreciate the court today.
All right. Defense, is there anything else with regards to sentencing?
No, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony, this is not filled out. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know. If you feel as though the probation officer is not addressing those issues, you can come back to the court and address them with the court. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, ma'am.
You're welcome.
Thank you, Judge.
You're welcome.
Have a seat.
Yes.
It's been going to confirm, security census for one case.
It's been dismissed. Yes.
I have Alexis Gonzalez. He's on Zoom. You can put that up there, please.
Who is here on
Thank you.
Lorenzo Garcia? Lorenzo Garcia. Christopher Rivera. Juan Aguilar.
Judge Christopher, that's the one that I gave you the file. It's supposed to be recalled for the 20th.
Okay. Okay. Hello.
Hello, ma'am.
Hi.
Hello.
All right, counsel. Who's the prosecutor on Ron Aguilar, please?
Ashley Jones for the state.
All right, so where are we on discovery?
Judge, I need to give the state a thumb drive. There's numerous medical reports. I can bring that thumb drive to them on Monday morning.
All right, and state, do you have all the medical reports?
I do believe so, Your Honor.
All right, is there any CPS records as well?
I believe they are, Judge.
And state, do you have possession of the CPS records?
We do have the medical records.
And Norma, I need a 45-day reset for discovery.
These are for you.
I don't show that we've requested CPS records. I don't have any confirmation that CPS records exist, but I will double check what was requested if so. March 24th.
All right, we're gonna bring you back on March 24th. And that will be for discovery counsel. Thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
Yes, ma'am.
Thank you. David, don't be a stranger.
I won't, Judge. I won't.
And what page is Juan Aguilar on? Thank you. Alexis Gonzalez. All right, so where are we on the PTD?
So we sent the signed agreement, we emailed it to the PTD division and we're just waiting for, I guess they have to get their signature and then
Okay,
he starts orientation.
all right. Alexis Gonzalez, if you can show your video, please. All right, Norma, I need a reset date for PTD.
March 18th.
All right, we'll be back on March 18th and your client can appear by Zoom.
Okay, thank you, Judge.
Thank you.
You have a good day.
You too. Seth McDonald? Already. Hello.
Hi, I sent records to your coordinator to reflect what the court requested.
Yes.
I don't know if the court had a chance to review those records. If not, I brought a copy, but it got it's scratch paper, but it does say on here that they did, in fact, take off his finger on February 8th.
Thank you. So state. Have you seen the documentation with regards to his finger?
I don't even think he knows.
All right, if you will, counsel, if you confer with the state to let them know what happened in this case, because there was an issue with whether or not his finger was amputated and what was going on, and that had to do with his reporting, because I'm trying to make a decision on whether or not to grant his application or not. So if you could speak to the defense attorney and they'll tell you what's on the documentation. And that may, if you can have a seat. And defense, that may make the state change their recommendations.
Okay, Ms. Jones is represented. It's not going to change their recommendation.
Okay. And Yaya, can you make sure that the NIMAC numbers reflect that they were taken in consideration? All right, thank you.
Everybody's coming. I'm good at
Oh, I got you. Yeah.
Tree? No. They're taking, they're coming away. Back return?
Yes.
After a spirited discussion. They are not changing their recommendation.
Okay. All righty. Let's bring everybody up then. Mr. McDonald, if you'll come down, please. All right, court is calling 2024 CR 5669 State versus Seth McDonald. Could I have parties announced for the record for the state,
The state of Texas?
for the defense?
Monica Guerrero for Mr. McDonald, Your Honor.
And are you Mr. McDonald?
Yes, ma'am. Yeah.
All right, you had entered a plea of no contest on September 10th, 2024. The court found that the evidence was sufficient to find you guilty. The court deferred finding of guilt because you had applied for deferred adjudication. The enhancement was waived without objection. The court ordered a PSI and TAP evaluation. On October 28th, 2024, we were scheduled, but defense counsel was in a jury trial. And I have to put this on the record. On October 31st, it was recalled for December 16th. Because I believe there was some sort of competency evaluation that was filed. And also, the court was awaiting the medical records to see whether or not your finger had been amputated. And then, of course, it was recalled again and again, but defense counsel was in jury trial. And also it was called again because we were awaiting medical records. And for some reason, someone thought that defense counsel should pay for the medical records.
And I did.
And she did. But that will be taken care of.
Thank you, Your Honor.
All right, so the court, the reason he stated that he did not report and he wasn't able to report because he had his finger amputated.
Correct.
So defense brought in records to show, in fact, that his finger had been amputated. If you would like to put anything into the record, defense?
So yes, Your Honor, they sent me a packet of 400 pages, actually 475 pages of medical records. I sent the pertinent part to the court through the court coordinator, which did in fact indicate from this doctor that his finger was amputated on February the 8th of 2024. And he was recommended to be out of work or to go anywhere because of the extreme pain that it caused.
All right, and state you still wish to proceed with your plea bargain agreement of punishment being assessed at a cap of 4 years? All right, so you're changing it because you all were previously opposed, so now you're silent?
Correct.
Any objection to the changing of the plea bargain agreement to reflect that the state is silent?
No, Your Honor.
Any objection to the court writing in the plea bargain agreement that the state is silent?
No objection.
Any objection? Do you have any objections, sir, that the state is now silent?
No, ma'am, Your Honor.
All right, so the court has received the TAP evaluation and the PSI. I previously on the record, both parties said that they had no objections to the TAP evaluation or the PSI. Is that the same state defense?
Correct.
All right. Mr. McDonald,
Yes, ma'am.
thank you for being honest with the court. Sometimes it's rare that people are honest. They still will let their attorney go try to discover something that does not exist. But in this case, it did exist. So I'm going to give you a choice. This is your only choice. There is no other choice. You understand?
Your Honor.
I can find you guilty and sentence you to 2 years in the prison, or I will grant your application for community supervision, and I will place you on community supervision for 4 years.
4 years probation.
All right. All right, the court will find you guilty. The court will sentence you to 4 years in the prison, suspended and probated for 4 years. There's to be regular reporting by Zoom or in person, regular random UAs. Probation, is he going to be with the special unit?
Yes, sir.
All right, you'll be reporting to the special unit. There is, and I know there are already field visits with that, so I'm not going to request field visits. There's to be Chapter 62 registration. You understand that?
Yes.
Do not miss that. Do you understand?
Yes, ma'am.
Proof of employment or SSI within 30 days, I'll say 45 days of release because based upon your charges, it's going to be hard for you to find employment. 45 days of release. Of course, there's to be no employment as a home health care provider or with minors. Probation, is there anything else? Is there anything else you need from the court to be successful?
No, ma'am, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am, Your Honor.
All right, we can go off the record. Good luck to you to be successful in this court. Communication is key. If there's an issue, let your probation officer know. If you feel they're not addressing it, you can come back to the court.
Thank you.
And you really should be thanking your attorney for finding all of this information.
Everybody loves me in jail.
Okay, all right, have a good one.
Thank you.
Thank
May I
you.
be excused, Your Honor?
Yes, and make sure you include that in your,
I will. Thank you.
all right, thank you so much. All right, and what page was McDonald on?
He's on the page stretch. He's on page 12.
All right, thank you. I don't know, either my vision is getting worse or something else is going on. April Diaz.
Here we go.
Thank you.
Okay, she'll be in the middle on the case.
Oh, is she currently without a bond?
Yes, Your Honor.
So does she have a warrant?
Yes, she does, Your Honor.
All right, so Ms. Diaz has a warrant.
I've
Court
heard-
is-
Oh, Your Honor, I had spoken to Satellite this morning, so I am prepared to walk her to Satellite if you're inclined to set a bond this morning.
Okay. All right, court is calling 2021 CR 2312 State versus April Diaz. Could I have parties announced for the record for the state
on the record, Your Honor.
defense?
Justin Fox, Your Honor.
And are you Ms. Diaz? All right, defense, you are here requesting a bond, is that correct?
Yes, Your Honor.
All right, defendant is currently on community supervision. Is there an agreement for a bond?
Yeah.
All right, and state, what is the agreement?
The agreement is to set the individual bond at $20,000. It was previously set at $15,000. Previous to, putting into the case, but we're also requested an ignition on the, installed on a vehicle, or if she's driving at all, for that matter.
All right.
And that is the agreement, Your Honor.
All right, can you raise your right hand for me, please? Do you solemnly swear affirm? the
Oh, she can't, Your Honor, because of the,
Oh, that's okay. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, state your name for the record.
April Diaz.
I'm not talking about now. I'm going to talk to you and ask you questions about in the past because I don't want to interfere with whatever defenses you may have with regards to the motion to revoke. So in the past, have you had any type of drug or alcohol issues?
No drug issues. I have, I've drinking alcohol, obviously, and taken necessary classes, paid as well. Just this past year, though, I did stop taking and going to AA.
All right. The court is going to set your bond at $20,000. There should be ignition interlock on all accessible vehicles. There should be no driving. And there should be 120 sober meetings. In 120 days. Is there anything with regards to the bond amount? Any other issues, state defense?
no, Your Honor. I've spoken to Satellite this morning. They are prepared to take her if I could be able to walk her down to Satellite.
Oh, the deputies will have to do that.
Oh, okay.
All right, so with regards to the motion to revoke, Ms. Ferguson, I need a contested hearing date in 20 days.
Oh, Your Honor, there, as far as discovery, it's a Bell County case for her new DWI, and they're very slow in that county as far as felonies and discovery.
I'm sure somebody can get a police report from Bell County. We'll see where we are.
Okay, yeah.
All right, February 25th,
We have the police report, is this other issue, but yeah, no
Okay.
problem.
for contested hearing. If you'll make sure she has a copy of the reset form, and then if you'll speak to the deputies, they'll make sure that she is taken downstairs.
Oh, thank you, Your Honor. Appreciate you.
It is 2021 2312 in DC. Okay, you're welcome.
They won't take her to one.
Oh, okay. I'll go take her out at one.
I recall.
Oh, yes. Oh, yes.
Okay.
I'll take her to work now.
You want to take all her property? You just start taking. Or she's gonna keep it. She, it's not, you have her.
I have a, yeah, I have a bucket going with me and, yeah. Okay, yeah, that's fine. Take your penalty for it, or-
Make sure that you.
Yes, I will. No, I won't.
Take her. Easier for us to do.
No. I will take her. I'll bring it for her.
That was the exhibit from earlier.
Laura, just for her to sign this. Oh, she's not going anywhere. I'll have her down.
All right, and is April Diaz on the docket today, or is that off docket? Okay. Brandon Bibbs. Court is calling 2025 CR 000937 State versus Brandon Bibbs. Can I have parties announced for the record for the state? Defense?
Derek Emmons from Mr. Bibbs.
And are you Mr. Bibbs? Counsel, have you received all discovery? Did you review it with your client?
I have, Judge.
Court will find that the state is in compliance. Is there an application?
There's not, Judge.
All right, Mr. Bibbs, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented? Attempted possession, 1 to 4 grams. Any objections?
Less than 1 gram. Judge, I believe that they need to proceed on attempted possession less than 1 gram because there's also a 1244 motion according to plea bargain agreement.
PG 114 is a third degree. and
Yeah.
An attempted is a state jail felony.
That is true, but I will tell you all, in the plea bargain agreement, I'm getting ahead of myself. It says that the state is proceeding on attempted possession, penalty group 1, less than 1 gram. Okay. So how are you all proceeding on it?
Andrew, I think you are correct. We would have no objection to that, Judge.
All right, so if you all will change this one. All right, did you review the document entitled admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand the state is proceeding on the lesser included offense, attempted possession of a controlled substance, 1 to 4 grams? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
You need him to initial this, Judge?
Yes. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering in this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he is, Judge.
Mr. Bibbs, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it? Did you sign it? I'm sorry, did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of attempted possession of a controlled substance, penalty group 1, 1 to 4 grams. They're asking that your punishment be assessed at 163 days in the Bexar County Jail under 1244. There's a $500 fine, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
There's nothing, Judge.
Then to the less included offense, how do you plead? Guilty, not guilty, or no contest?
No counsel.
State any evidence?
Standing to test.
No objections.
All right, state you may be excused. Did you review the waiver and steps with your attorney? Did you understand it?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We would like to judge today.
Anything you wish to say on behalf of your client?
Just that, Your Honor, he's been in custody for 163 days. We're asking the court to run the time of money concur and make the judgment satisfied.
And what happened to the assault case?
The misdemeanor assault that's referenced in the police report was part of a continuous family violence case that was no bill by the grand jury.
So what, hasn't been sent to the grand jury, or
It
has
has
it?
been no bill.
All right. This is what the court is going to do. The court is finding you guilty. The court will follow your agreement, sentence you to a $500 fine, time and money to run concurrent. There's 163 days in the Bexar County Jail under 1244. There's to be no contact with Freda, Freda, Everett, Everett, and no contact with Cincinnati Avenue. And the court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
How long would be the paperwork? No contact.
You're not to have any contact with her. Here's the thing, and we're off the record. If you love somebody, you shouldn't put your hands on them in anger. I know they're saying it was no bill. I have no idea why it was no bill or what was going on. But if you ever get to a point in a relationship where the police have to be called out, then that's not a good relationship.
I'll talk to you about that.
Thank you.
All right, thank
Maybe
you.
excuse judge.
Yes.
Thank you.
Either way.
And what page is this on?
It's on page. Okay, Dave.
Thank you.
Yes, ma'am.
All right, who's here on Adriel Trevino? Yes. Good morning.
Judge, I caught the interpreter. She's on her way. Could you need an interpreter?
He needs an interpreter, Judge.
All right, so we're waiting for the interpreter. to
Thank
come.
you, Judge.
All right, they're not ready on that one. No problem. Who's here on Ezekiel Martinez?
I am Judge.
All right, where's Mr. Martinez?
He is in the back. He's in custody. So Judge, we were here a few days ago and you said it for today, but I didn't realize when I pulled the discovery on e-discovery that there was a DVD with like 10 videos. So I went to the back to try to open it. I can't.
Okay.
I need more time. Can you set it maybe next week sometime?
Sure. And you want to make sure with the state that that actually will open?
It was downloading back there.
Oh, the equipment here is not the best of equipment.
And there's like 10 videos.
All right, Ms. Ferguson, if you recall this for February 13th,
Yes, ma'am.
February 13th.
and that's the final plea deadline date.
Okay. Thank you, Judge.
Do you wish to see your client?
No.
All right, Ms. Ferguson, he can be sent back. Deputy Laura, Ezekiel Martinez can be sent back. If you'll let him know that his defense counsel, the video would not open. Thank you.
Thank you, Judge.
You're welcome. Yes. Yes.
You talking bids?
You're talking good.
Guzman?
You're on the ramp, bro. Come on.
Yes.
I'm here. I'm present. I'm here. Judge, we're still, this is a.
Oh, is this Guzman?
Yes,
Is it on the docket today?
it is. Justin,
So he needs to come up.
he's in custody, Judge, and we don't know where he's in custody. It's a probation review. And he's on a bench warrant out of your court.
Okay, so just give me 1 second.
Yes.
I don't know, I'm looking for it of this. Oh.
All right, so state. Who is on Guzman? It's a criminal trial division. So, with regards to Justin Guzman, the court's understanding that he was in custody, but nobody is able to locate him. At one point, he was in Atascos County, then he was maybe in Jordanton. So does anybody know where he is? Is he in custody?
I think he is, Your Honor. From the last time we checked, we were here 2 weeks ago. And they tried to find him at Datascosa, but they had already transferred him. He's supposed to be doing 16 months on the charge over there. But,
16 months in the state jail?
Yes. I did try contacting his mother. I had a phone number I called, but I never got a response.
What was the first name?
Justin, Justin, yeah, Guzman.
Oh, Guzman. I mean, there's see if I can look at my phone.
How old is he?
37.
Ah. Well, the only Justin Guzman they have in the state jail facility, they have him listed as 26. And I don't think this is the same Justin Guzman.
It's not Judge.
It's not.
It's not. It's the one. It's the one, we looked up last week and we called. And we
Even
fine.
you check the other counties that were listed in the supplemental as well. We found his information on there, but it says that he was on hold for another county or something, or transported to another county, so I think he's in between like 3 or 4 counties that are wanting him.
Well, there should be something in somebody's system, like Texas should have a general system.
And can you put that,
All right, just one moment.
the interpreter too.
No, I'll wait.
I was trying to
Okay.
get things going. I've injured my knee very badly.
Oh, you gotta take care of that.
I have a
Norma, recall this for the end of the month.
27.
All right.
judge. Thank you. May I be excused?
Yes, you may be
Thank you.
excused. Good luck on the knee.
I'm gonna hopefully get it injected today.
Ah, okay.
Thank you.
All right, Adriel Trevino.
Good morning, Your Honor.
Good morning. All right, so where are we on discovery?
Judge, we got some of the discovery. They just filed the second indictment on unauthorized use. I just received it today. I spoke with Mr. Adriel Trevino. He wishes to, he asked me to request a MAC immigration consultation.
Okay.
And we want to do that, Judge. He just told me that he may have some issues with immigration. His wife is an American citizen. So I don't know where his process of immigration application is going. So we just need a reset so we can do the MAC.
All right, Norma, if you recall this in 30 days for immigration attorney?
Yes, ma'am.
Thank you very much, Your Honor.
March 17th, just.
March 17th.
That'll be fine, Your Honor.
You're welcome.
I'll call Mr. Tillis to try to work on this as soon as possible.
All right, is there anything else?
Nothing else, Judge. This is our first setting.
Thank you. Good seeing you. Have a good one.
Thank you, Judge Boyd.
Thank you.
Mr. Montoya, I'm gonna send you a link. For this immigration thing. Okay.
What page is Guzman on? It seems like the MTRs and PSI are all over the place on the docket.
Who, Judge, I'm sorry?
Guzman.
This one is on page. 10 at the bottom. Judge.
All right, thank you.
Not yet.
I'll put De La Rosa up there too, Johnny De La Rosa. They're pretty much the same self.
And Norma, on Trevino, if you make sure that the record reflects that there was an interpreter here.
Yeah.
Niño.
Yeah, that's fine. Jason says he's ready to.
Christopher Rivera. Lorenzo Garcia. Johnny De La Rosa.
Judge, Mr. De La Rosa was the gentleman who was in the box had a bit of a emotional outburst that he had just left.
Yeah.
And I've been here all morning reviewing videos with my other client. I've got somebody in my office at 1 o'clock. Can he come back tomorrow so I can, we're trying to work the case out. I was gonna show him his videos. Or if we can do it maybe Tuesday, because I can't stay
All right.
this afternoon.
So, we can recall it for the 10th.
Okay, that works for me. Thank you, Judge.
Deputy Laura, if you'll have Mr. De La Rosa come back on the 10th. And there'll be no further resets for plea deadline because this is his fault.
Hopefully he'll be able to contain his emotions, Judge. Very passionate.
Okay. Broderick Lewis. Court is calling 2024 CR 011541, State of Texas versus Broderick Lewis. Can I have parties announced for the record for the state? Defense? And are you Mr. Lewis? Counsel, have you received all discovery? Did you review it with your client?
Yes, we did, Judge.
Court will find that the state is in compliance with discovery. Mr. Lewis, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented? Did you review the court admonishments with your attorney? Did you understand it?
Yes.
You're charged with the offense on unauthorized possession of a catalytic converter. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he is currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Lewis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state recommends deferred adjudication. There's to be restitution to the complainants. Al Human, Houman, Naj, Najah, Al Salshi, Alshalchi, and Joshua Turner. Did you understand that to be the plea? Defense is at the plea.
It is, Your Honor.
State is at the plea. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation, community service hours, no contact with the complainants or John Fomba, Fomba, and MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
State offer states exhibit number 1 and attachments.
Any objections?
No objection.
State you may be excused. Did you review the waiver and consent with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Would actually, would be able to, Judge. Yes.
Anything you wish to say on behalf of your client?
Judge, he's been in contact with me, very respectful young man, came dressed appropriately for court. Is remarkable for what he did. We'd ask that you follow the plea bargain. Also, as a condition of his bond, he has an ankle monitor, which his understanding was he was to remain home 24/7. We'd ask that that be removed since it was a bond condition. And I also ask that the court, if the court does grant the deferred, that he be allowed to transfer the probation to Harris County, Houston, Judge.
All right, why are you still in catalytic converters? Do you know how much catalytic converters cost? Yeah, so you're just out in the streets, just stealing randomly. So even though you don't know how much it costs, why are you stealing catalytic converters?
Just made a stupid decision, hanging with the wrong people.
No, if I would have talked to John, John would be before me, and you know what he'd say? His attorney would say he's dressed for court appropriately and he's always respectful to me. And John would say, just made a stupid decision hanging with the wrong people. And I would say, who are the wrong people? And you know what he'd say? You. So how far did you go in school?
Graduated high school.
So what are you planning on doing with the rest of your life?
Finding a stable job so I can take care of my family.
Do you have children?
Yes, ma'am, I have one.
Age?
She finished turn 3 on the 18th.
And where does she reside? Is she in Bear County?
No, she's in Houston.
Okay. All right, if you're drug tested today, where are the results going to be?
I mean, positive.
For what? All right, so he's not on the right track yet. You are not allowed to smoke marijuana while you're on probation. You shouldn't be smoking marijuana anyway because you have a young child. Do you want your child smoking marijuana? Then you have to be a better example for them. You understand? Everything that you do, your child watches, and that's how your child learns how to behave. You understand? All right. 4 years deferred adjudication, restitution, and no contact with the complainants, and no contact with John Fumba. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. Make sure they test for levels. There's to be a transfer to Harris County. And if they do field visits, I want field visits 1 time per month until further notice. There's going to be 200 hours of community service restitution. 100 of those hours will be waived upon completion of parenting classes. The remaining hours will be waived if he obtains some sort of higher level education or trade school certification. Here's your moral recognition therapy course. Don't steal, do what's right. Are you able to do that? Do you know right from wrong? Then do right, you understand? And you'll find that doing right is easier than doing what's wrong, because when you do what's wrong, then you have to lie to cover it up, and it's just a whole host of nonsense. You understand? Probation, is there anything else he needs? Yes, proof of employment within 30 days. There's no employment as a home health care provider or with minors. And there's to be no unsupervised contact with minors until completion of parenting classes. Anything else, probation? Okay. Anything else you need in order to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Good luck with you.
Yes, ma'am. Thank you very much.
You're welcome.
Thank you, Judge.
You're welcome. Nicole Nutter. Hi.
She's in custody, Judge.
All right, it should come down. Oh, I'm so sorry. On the last case, state any objection to removal of the GPS? All right, and probation GPS will be removed. All right, court is calling 2024 CR 011162, State of Texas versus Nicole Nutter. Could I have parties announced for the record for the state?
Albert Chidas for Ms. Nutter.
And are you Ms. Nutter?
Yes, ma'am.
All right, you entered a plea on December 20th of no contest. The court waived the repeater allegation without objection. According to the plea bargain agreement, punishment is to be assessed at a cap of 5 in the prison. There's a $2,000 fine, and the state is opposed to your application. Have both parties had a chance to review the PSI report and the TAP evaluation?
Yes, Your Honor.
Any objection?
No objection, Your Honor.
Any witnesses?
Yes, Your Honor.
All right.
I'd like to call my client.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Nicole Nutter.
All right, defense.
Ms. Nutter, you're applying for probation. What can you tell the judge that will give her confidence that you're gonna succeed at probation?
And when I plan on getting out, I plan on getting a job. Staying with my daughter. And just trying to get on with my life and do better. I don't do drugs anymore.
I'm sorry?
I don't do drugs anymore.
Okay.
My legs were run over on December 6th, 2023. And as soon as my legs were run over by the vehicle, it snapped me into reality. And I haven't done methamphetamine since the day my legs were run over.
Now, let me ask you another question. Have you had mental health issues?
They diagnosed me when my daughter was just born, and I denied the drug that they diagnosed me, Deferred, and I told them that I wasn't gonna take it because my daughter was young and I didn't want to be on medicine. So all these years I've been without
Okay,
healthcare.
but what were you diagnosed with?
Bipolar,
Okay, and the Depakote was to treat the bipolar disorders?
yes,
And you were not on your medication?
no.
Okay.
not on my medication.
Now, on this instant offense, were you using methamphetamines when you were arrested?
No,
Were you taking your Depakote or something similar?
no, I wasn't taking anything. I know I had a psychotic breakdown, a mental breakdown. Because there's nothing else that can explain it. I wasn't under the influence of anything.
All right, so here's the thing. You're gonna need to speak up so the court reporter can hear, and everyone else, you need to whisper.
So
And so, when you went over, what was this trailer place that you went to?
it was my friend's house that I was living at.
And were you allowed to be there at the time?
Yes, I lived there with him.
But were you allowed to be there at the time that you went there, when you got arrested?
At the time, well, I didn't think anything of it. Even though we had like a little dispute a few days like before that, I didn't think because he's my friend.
Had he kicked you out?
Well, he gave me my clothes and I went to spend the night in another friend's house in the
Okay.
trailer park.
Okay, and so, did you intend to burglarize his home?
No, not at all. I just.
What was the
intended to
reason you went there?
Talk with him about
Um,
the cats that I let out of the cages and to let him know what was going on, and what I had done.
okay, now, if the judge is gonna consider probation, she's gotta consider what the likelihood that you're gonna successfully complete probation. So you've had probation before, right? And you've struggled with probation.
Yeah, I've struggled in the past.
Has bipolar disorder been an issue?
I believe it's always been an issue. That's why I got myself medicated with methamphetamines. I never got treated until now. And the medicine that I'm on just works really well. I haven't had any of those breakdowns mentally that I was having before all this happened.
So while you've been in county, have you been put on medication?
Yeah, they put me on Risperdal.
Okay, so if the judge decides she's gonna give you probation, do you have a place to go since you're not gonna be living with Tim anymore?
I have my daughter's house. My daughter has an apartment. She's 21. She's here today.
Okay, and so do you have any additional family support?
Her, my children's father.
Okay, all right. Thank you. No further questions, Judge.
Any questions?
Your accident where your legs were run over, you said that was in 2003?
2003, December 6th, 2003.
And so when have you stopped?
Oh, no, 2023.
Oh,
Sorry.
2023.
23,
Okay, so
yes.
that's when you say it's getting
Yes.
stopped doing drugs.
Yeah.
Okay, and so I just had a question because you said, I mean, You have been living there with Timothy, correct, at the trailer?
Yes.
Okay, and you guys got into a disagreement a couple of days before and regarding the cat, correct?
Well, we hadn't really talked about the cats at the time, so that I wanted to go and talk with him about letting the cats out, because he didn't hear from me. He only heard from the tenants, so he had never heard it from me. So I wanted to go over and talk to him and let him know what was going on.
And then, but that day, I guess, he had given you your clothes previously to go stay somewhere else, is that correct?
At the friend's house.
Okay. And so then the day that you went back to speak to him about the cats, and you believe that you had permission to be there that day?
Yeah, of course.
Okay, even though he didn't really let you into the apartment, right? In the police report, it said that you headbutted him, but you're disputing that today, right?
No, it wasn't a headbutt, it was,
Kind of like checking him.
chest, yeah.
And at one point he fell down and you're going back and forth with the chest,
Yeah.
correct? Okay, and then you enter his habitation, his trailer at that time, correct, and lock the door.
Yeah.
Okay, and to you, that indicates to you that you have permission to be there?
No, my mental state wasn't normal.
Okay.
I mean, in reality, my mental state was really messed up.
Okay. And in the stipulations that Timothy had said that he didn't know if you were using drugs again, but you're saying that you're not, and it's just a mental health issue.
It was a mental health issue for sure. I mean, my mental health was, I can't even tell you what kind of things were going on in my head at the time that were just not even normal. When I entered Bear County, they put a yellow shirt on me. I thought I was pregnant. I haven't had to sex
Well, that's okay. We don't have to go into
since
that.
December 6th.
That's
So,
okay.
yeah.
I'm done asking you questions. Okay, I've kind of clarified what I want.
All right, any other questions?
No other questions for her. I do have one other witness, or I don't know if the court needs to hear, but her daughter and her ex-husband are here. The daughter would just be testifying about the fact that she can provide a home for her mother.
Okay,
I don't know if you need to hear from her. It's sufficient just to know that.
that's fine for me to know that, but if you would like to call them as a witness, we'll have to bring this back in the afternoon.
No, we don't need to do that, Judge.
You sure?
Yeah.
You sure?
Well, out of an abundance of caution, I would like to call the daughter just to.
All right, so we'll come back in the afternoon at 1:30 and we'll finish up this hearing, okay? All right.
Thank you.
You're welcome. All right, James Wilkins. Who's the attorney for James Wilkins? All right, so competency file.
Yes, and he was evaluated on January 27th. We're just waiting on the doctor's report.
All right, so Ms. Ferguson, if you will set this in March, it should be.
We're on the record, hold it down, please.
I'm sorry, Judge, I couldn't.
If you'll reset this for March, please, for competency. He's been seen, we're just waiting for the evaluation.
March 27th.
All right, so we'll come back on March 27th. If the competency report is presented before then, your attorney will let us know and we'll come back sooner, okay?
Yeah.
All right, thank you.
Thank you.
Thank you, Mr. Wilkins.
You too.
Take care. Yes, Sharon. Thursday.
What page is he on?
He's on the first page at the bottom, Judge.
All right, thank you. All right, who's here on Raymond McKinney?
I am, Judge.
All right, so this is plea deadline.
Yes, so I've conferred with the state, conveyed the offer to Mr. McKinney. He's rejected the offers. There's two different sets of dates.
Mhm.
And so they're both kind of strange cases, so I was gonna request motions to suppress on each one, and we're gonna file speedy trial motions and motions to quash as
All right.
well. And I'm not sure how the court wants to handle that.
So is the motion suppressed? Is that going to be dispositive?
I don't think so, unless, of course, I win, but I would say no.
All right. And do you want a jury trial or a bench trial?
Jury trial, please.
All right, Ms. Ferguson, then your motion to suppress will be ran with trial.
Okay.
And Ms. Ferguson, I need a jury trial date. And of course, if you want to have your, well, this is the as speedy as a trial I can give you unless there's some other reason for a speedy trial.
And on the motions to quash, but you'll just share those before.
Yes.
And when we try the cases in order, we have a June offense date.
If y'all want to confer on which case.
Okay.
All right.
Judge, I can do March 4th.
All right, March 4th.
Of the.
All right, your jury trial date will be March 4th.
All right, thank you, Judge.
Thank you. Craig Cantu?
Your Honor, can you call this to next week, the 12th or the 14th? We're still negotiating with Ms. Ashley Jones.
Okay, just
12th.
1 second.
Yes.
All right, and do they have a file? Because last time there was no file.
They did have a file that I waited for them to bring it down. And it may not have been coded correctly in the system.
I think that was the issue, Your Honor, so we'll get that fixed, but we do have it in the session.
All right, Norma, recall this for February 13th.
Yes, sir.
If it could be the 12th or the 14th, Wednesday or Friday.
No. It could be the 10th, the 11th, or the 13th.
If I may check. Um, 13th.
The 13th? All right, we'll see you back on the 13th.
Thank you, gentlemen.
You're welcome.
And
Christopher Rivera? All right, we are going to take our break. So everyone, please come back. Well, not please. Everyone is ordered to be back at 1:30. Hunter, I'm trying to stop saying, please, would you please come back? Judge Angelini is like, no, you order everybody to be back. So everyone is back at 1:30.
I appreciate the bail.
Thank you, Hunter.
Polite orders are great, Judge.
Nutter.
They're still orders.
Yeah, okay.
So, Judge, on that Christopher Rivera.
1:30.
Needs to be set.